You get it? Well, I hope you do. Now, the last is yung pinaka mahirap. Well, not the last, no, but the next part is yung pinaka mahirap sa natitirang sections ng Bill of Rights, no? The right against double jeopardy. Right? So let us go into it. The right versus double jeopardy. Section 21 says, no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Okay, first thing that I want you to do, no? Marami kasi, by reading the text, nako-confuse sila eh. Para huwag kayong ma-confuse, okay, read it again, silently. But in your mind, replace the word jeopardy with the word danger. Okay? So let's try that. No person shall be twice put in danger of punishment for the same offense. O, di ba mas madali intindihin? Why can't you be put in danger of punishment? Kasi class, again, balik na naman tayo, presumption of innocence. The burden of proof is on the state to prove your guilt. And in proving your guilt, they only get one chance. Hindi pwedeng paulit-ulit. They only get one chance. Okay? So, if you have already been placed in danger of punishment once, the state cannot do it again. Because if they failed once, then they failed in proving your guilt. Okay? Second thing that I want you to remember, please read it again. Sorry, Section 21. Please note, the first sentence uses the phrase, same offense. Did you notice? The second sentence uses the phrase same acts. Tama ba? Meron bang same acts dun sa... Okay. If an act is punished by a law and an ordinance, walang phrase the same acts, but it refers to the same act. The first sentence uses the term same offense. Okay? And the second sentence talks about the same act. Okay? Please take note of the difference. Okay? Because pareho will constitute double jeopardy. Okay, now let's look at some of the cases. Let's look at the elements first. So when will double jeopardy come into play? Double jeopardy, you can invoke your right against double jeopardy the moment the Supreme Court, this is the term the Supreme Court uses. The moment the first jeopardy attached, okay, the state can no longer put you in danger of punishment again. So what does that mean when it says when the first jeopardy attaches? That simply means when you are already in danger of conviction, in danger of punishment. When are you in danger of punishment? Simple. When you are charged with a valid complaint or information. Kasi if the information is not valid, diba, you cannot be validly convicted. So you are not in danger of punishment. Second, if it is filed before a competent court. Again, conversely, if the court has no jurisdiction, you can have no valid conviction, therefore you are not in danger of punishment. Okay? Third, the defendant had already pleaded to the charge. In other words, arraignment was done. Okay? Kaya importante yung arraignment. Why? Because as we learned in section 14, no? That is the time when you are formally informed of the nature and cause of accusation against you. Okay. So nangyari na to. Valid information, competent court, and you were already arraigned. Okay? And then, you're acquitted, convicted, or the case was dismissed or otherwise terminated without the consent of the accused. Okay? Express consent. So, if all these four are present, this is what the Supreme Court says, the first jeopardy has already attached. In other words, there was already, for the same offense, right, under sentence 1 or the same act under sentence 2, okay, you were already in danger of punishment. Okay? Either for the same offense under sentence 1 or for the same acts under sentence 2. Okay? So, let's look at some of the cases. People versus Judge Santiago. Judge Santiago here, there was a case filed by UP against a squatter. No? Criminal case. Pre-trial, the judge, without presentation of evidence, pre-trial pa lang decided to acquit the accused. Okay. So, here, pre-trial. So, ibig sabihin, tapos na arraignment. Okay. Was there a valid information? Let's assume so. Was it before a competent court? Let's assume so. But did he plea? Yes. Kasi pre-trial na. That means tapos na yung arraignment. Okay? And then he was acquitted. Did the first jeopardy attach? Dapat, the answer is yes. Because all four are there. Right? All four are there. But, please take note, the Supreme Court said, no, the first jeopardy did not attach. Why? Because the court, in deciding to acquit the accused before trial, committed grave abuse of discretion, amounting to lack of jurisdiction. In other words, while it is true that it was originally filed before a competent court, that court lost its jurisdiction when it acted in grave abuse of discretion. And therefore, in the four elements of jeopardy, the second element was gone. Right? It was no longer a competent court. While it started as one with jurisdiction, when it acted with grave abuse of discretion, it lost its jurisdiction. Therefore, double jeopardy will not prevent the appeal from proceeding. Okay? Now, People versus Obsania. Here, there was a rape case filed. Unfortunately, after the arraignment, the accused moved to quash, claiming that the information is defective. After the arraignment, And again, unfortunately, the court agreed, granted the motion to quash. So the Republic appealed. Sabi ng Republic, uy, mali yan. Kumpleto ang allegation namin sa information. Please take note, Valid complaint or information, competent court, after arraignment. So the accused already pleaded. And then it was dismissed. Okay? Did first jeopardy attach preventing an appeal? No. Why not? Because the dismissal was not only with the consent of the accused, it was actually upon his motion. Diba? Fourth element, the case dismissed or otherwise terminated without the express consent of the accused. In this case, not only did he consent, it was upon his motion. Bakit ba pag upon his motion, jeopardy will not attach? Well, the Supreme Court explained in this case because of the twin doctrines of waiver and estoppel. Bakit may twin doctrines ng waiver and estoppel na involved here? Just like in this case, the accused claimed the information is defective because there was an element daw of the crime, lewd design, right? That was not alleged in the information. So when he filed a motion to dismiss, right? When he filed a motion to dismiss, he claimed the information was not valid. Granted, nag-appeal ang Republic, sabi niya double jeopardy. Pag sinabi niya double jeopardy, he is now saying he was charged with the valid information. O parang hindi pwede yun. Stop ka na. Sinabi mo noon, di ba? Incomplete and therefore invalid yung information. On appeal, you cannot turn around and say valid yung information. Stop ka na. And because stop ka na, you are deemed to have waived any rights in relation to Section 17. Clear? Clear? Which is why, class, The twin doctrines of waiver and estoppel will only apply if the motion was of that nature. Okay? The motion was of that nature. In other words, if the motion to dismiss is based on something else, on the substantive merits of the case. For example, motion to dismiss on the ground of failure to prosecute. Not because the information is defective, not because the court has no jurisdiction, but because the prosecution failed to prosecute. If that motion to dismiss is granted, will jeopardy attach? Yes, because a motion to dismiss based on failure to prosecute is, and if it is granted, is actually unacquittal. Okay? Same is true. Motion to dismiss based on right to speedy trial. Prosecution has failed to prosecute for an unreasonably long time. If the court grants it, that is actually unacquittal. So a dismissal on the merits is different, no? Because a dismissal on the merits is actually unacquittal. So these twin doctrines of waiver and estoppel only applies, no, when they are attacking some technical aspect regarding the jurisdiction of the court or the validity of the information. Clear? Then there is Melo versus People. Here, the accused was charged with frustrated homicide. He was arraigned, right? So he pleaded not guilty. But after arraignment, the victim died. So the prosecution moved to be allowed to amend the complaint from frustrated homicide to homicide. Sabi niya, teka, na-arraign na ako. Oops, what happened? Can you still see me? I clicked something. Ayun. Sorry. Sabi ng accused, teka, na-arraign na ako. Jeopardy attached. Is he correct? No. Why? Jeopardy requires that he be charged with the same offense. But isn't it true? Frustrated homicide and homicide is same in the sense that frustrated homicide is necessarily included in homicide. Well, yes. But remember, at the time that he was charged, the crime homicide did not yet exist. Why not? Eh, buhay pa yung victim eh. Diba? Well, the victim is still alive. The prosecution could not have charged him with frustrated homicide. So in that sense, it is not the same offense. Therefore, jeopardy did not attach. Okay? In Lejano versus People, this is that famous case of the Visconde massacre, no? Alam niyo na to, di ba? Di ba? Si Hubert Webb was charged with the Visconde massacre, convicted with the RTC, spent 14 years in jail. After 14 years, the Supreme Court came up with a decision and said, incredible witness with an incredible story, they should not have been convicted, and they were acquitted. This is a motion for reconsideration. And here the Supreme Court said, sorry, no. Remember, I told you, the prosecution only gets one chance. One chance. If they fail to prove your guilt beyond reasonable doubt, that's it. That's the end of the road. There is no appeal from an acquittal. Because a motion for reconsideration, double jeopardy. Right? Because a motion for reconsideration will put you again in danger of punishment. An appeal, double jeopardy. Why? Because an appeal will again put you in danger of punishment, and they should only get one chance. Okay? Except, of course, gagamitin niyo yung UP case na the court lost its jurisdiction because of grave abuse of discretion. Exceptional yun. But as a general rule, no appeal from an acquittal. So in this case, the Supreme Court explained, nag-MR ka, motion for reconsideration, we cannot even entertain that. Okay? We cannot. Because that will put the accused twice in danger of punishment. And that is prohibited by the Constitution.